Great. So, good morning again, everyone. Thank you so much for joining the session. Just in the interest of time, I think we'll start the session now. I really appreciate that all of you have taken the time to join us today. Uh, we are going to speak on a very interesting topic that is called trusts. Trust is one of the ultimate tools of estate planning, and it helps in transfer of assets within the family in a very effective manner. We'll just give a brief about our firm to start with, and then of course we'll be more than happy to hear from Deepak sir about his about to learn more about trusts. I'm sure I think you will be able to see my screen.
Yes.
So Fin Chikitsak is our brand. We started this firm. My father, Mr. Kamaljeet Gupta, started this firm about 10 to 12 years back. As many of you know, he's an alumni of BITS Pilani and IIM Ahmedabad and has a lot of experience in the equity markets. He started this more as a hobby, and by grace of God, we have grown by the love of our clients. Myself, I am an alumni of MDI Gurgaon and NIT Surat, and I was working with banks like Amex, Citi, and Credit Suisse prior to joining my father on a full-time basis. We offer numerous products and services to our clients, which includes mutual funds, insurance, loans, tax advisory, alternate investments, as well as estate planning. And today that we are going to speak on is a part of the trust is one aspect of estate planning that we'll get to learn more about today. We try to do these webinars consistently for our clients on different financial topics. Um, a bit about our speaker today, Deepak sir. He's the co-founder and director of AAFM India, that is American Association of Financial Managers. He is the founder and director of Next Gen Estate Planning Solutions, and also the founder director of Financial Literacy Advisory Board of India. I think the credentials that you see here are the slide would have fallen short of his credentials, and the list goes extremely long. It shows that his commitment towards education, towards training people to ensure that we are on the right track, on the right path. It's an honor, to be honest, to have you, sir, again. We had met at Gift City recently when when sir had hosted a 2 day seminar for all of us at Gift City near Ahmedabad. It was an enlightening session of how Gift City is being developed and the various offerings that we have in India today for our NRI and foreign clients, as well as opportunities for us to invest outside of India. So, again, sir, it has always been great to learn from you and to have you as a mentor. Thank you so much for coming with us today and taking the session for us. Without further ado, sir, I will pass it on to you and to please take today's session, sir.
Thank you very much. Thank you, Akshat. So let me start the session. Okay, so I know most of you might be there in the last session of mine, but I'll just revise that a little bit and then move forward because without that, this would not make much sense to you. And without the base, you can't build the building. So, whenever I start this session on inheritance and succession planning, I always ask a question. And the question is very simple. If you die today, what would you leave behind for your family and children? An inheritance or a mess? Will your wealth be a source of joy for them or source of trouble? तो हिंदी में इसका बेटर वर्ड्स हैं कि आप अपनी मृत्यु के बाद संपत्ति छोड़ के जाओगे उनके लिए या विपत्ति छोड़ के जाओगे उनके लिए, राइट? एंड दिस estate planning is all about how to actually leave an inheritance, not a mess for your children. And in the last session, I talked about the four basic documents which every Indian should have to actually leave an inheritance, not a mess. And those four documents, I'll just revise quickly before I move to the trust, which is the topic of today. First is a will. Every Indian adult should have a will, right? It is something which is mandatory, irrespective of your social strata, economic strata, your number of people in your family, number of legal heirs, doesn't matter. If you are a major and you are of sound mind, you have some assets, you should create a will immediately, right? Second document which all of us should have is something called letter of guardianship. So many of us have minor children, and in case both of us pass away while the child is minor, this is a document which allows you to give custody of the child to the person chosen by you. So you can appoint testamentary guardians for your children through a letter of guardianship. So if you are a couple or a parent with minor children, your most precious asset is your child. And today you have left them unprotected by not creating a letter of guardianship and appointing a custodian or the guardian of the child who gets the custody of the child after you. The third document which we talked last time is about disability. Suppose you are in coma, you are paralytic, you are mentally unsound. Under such situations, who would be able to operate your singly operated bank accounts? Who would be able to operate your singly held mutual fund folios? Who will be able to take rent on a property which is rented by you? And who would be able to renew this rent agreement? And what have you done for it? And what can you do for it? For that, we create a document which is called Springing Durable Financial Power of Attorney for Incapacitation. It's not a normal power of attorney, it's a special power of attorney created for incapacitation disability, which allows somebody to step into your shoes and do whatever you have allowed them to do in this document. That's called Springing Durable Financial Power of Attorney for Incapacitation. And the last document which we talked about in the last session was something called a living will. For that also, I'll give you a situations. Imagine that you are on a ventilator for more than 15 days, less than 5% chance of reviving, and actually brain dead. But doctors keep you artificially alive. Why? Because they are legally obliged to do it. And maybe some of them think that we are making money on his or her body. So what's the risk? The first risk is you are in lot of pain. And second risk is your wealth is slowly lost to a nursing home, hospital, or a doctor. Can you do something about it? Yes. You can create something called a living will where you specify conditions under which life support should be withdrawn from you. So you can say if I am on a ventilator for more than 10 days, less than 5% chance of reviving and brain dead, please switch off the ventilator, keep on giving me painkillers because I refuse to rot on a bed. And that is done through a living will. So four documents which are compulsory for all of you is a will, a letter of guardianship, springing durable financial power of attorney, and a living will. If you create these four documents, then maybe you leave an inheritance, not a miss, right? But I want to remove that maybe. And the only way to remove that maybe is a trust, right? If you want to ensure that you only leave inheritance, not a mess, trusts are the way to go. Where estate planning becomes an art, not a science. It is at the trust level. And I am very sure working in this field for last now 10 years that every Indian should have a trust. Every Indian family should have a private family trust. I am working on this, more and more I am convinced about it. So today I'll demystify the trust for you because whenever we talk about trust, people think about those charitable trusts. Yeah. So we are not talking about those kind of trusts. We are talking about private family trusts, right?
Uh,
So let
Sir, sorry to cut you, but thank you so much for the background. I have also shared the link of the webinar that Sir has done on the chat box. Please feel free to, to listen to our last webinar using the YouTube link. Also, I got a message that the voice is very low. Can you please let me know if 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 you're able to hear us clearly? Can probably someone
Yeah,
let us know in the chat
yes,
box if
Akshat,
it is clear?
all clear.
Okay, great. Thank you so much for the confirmation.
Thank you. So I'll just continue just a minute. Okay. So private family trust as an estate planning instrument, this is what we'll be discussing today. So what are private family trusts? How are they structured, etc. We'll be talking about in the first part. What is a trust? Now, this is the best known definition of trust, where they say a trust is a relationship between three parties where property, either real, personal, tangible, or intangible, is transferred by one party to be held by another party for the benefit of third party. If A gives his property to B for benefit of C, this arrangement is called a trust. Right? This arrangement is called a trust. You have given your property to B for benefit of a third person called C. That arrangement is trust. And to simplify it further for you, let me discuss it in a graphical manner. All of you know company, a private limited company. It's a separate legal entity than the individual. Likewise, trust is a separate legal entity than an individual. In a company, the person who starts the company is called the shareholder. The same person becomes the settler in a trust. The person who starts a trust or creates the trust is called the settler. In a company, the person who manages the day-to-day affair of the company is called a director. The same person becomes a trustee in the trust. The person who manages the day-to-day affairs of the trust is called a trustee. Now, in a company, all profits and assets belong to the shareholder. But in a trust, there is a difference. But in the trust, there is a difference. And difference is all profits may belong to the settler, person who started, or on the direction of the settler can be given to a third person. That's what I said. If A has given his property to B for benefit of C, A is the settler, B is the trustee, C is the beneficiary, right? So if A gives his property to B for benefit of C, that arrangement is called a trust, right? A trust should have a trust fund, a settler, a trustee, and a beneficiary, right? These are some things which are common inside a trust. It will become more easy for you to understand when I give you the use cases, right? So right now it's a little heavy, I know, but just bear with me for another 5-10 minutes, right? Okay. A trust must have following elements to make it legally enforceable. And this I have done with you. First is settler who creates the trust. Second, purpose of setting the trust. Why am I setting this trust? What's the reason? What is the property to be settled in the trust? And beneficiary who benefit from the trust. And the fifth is trustee who takes the obligation to hold the trust property for the benefit of beneficiary as per the trustee. So somebody who takes care of these assets which are transferred to the trust, right? Now, what are the components of valid trust? For creating a trust, legally it is essential that four conditions are complied with. First is the settler makes an unequivocal declaration binding on. Unequivocal means very clear, without any conditions. A declaration which is binding on it that I am giving my property to the trust. The settler should outline why he is creating the trust. The settler should clearly tell who are the beneficiaries of the trust and then transfer some property to the trust under this arrangement which he has made for the trust. What are the reason why you should form a private family trust, right? A very important question which comes, why should you form a trust? So these are four major reasons why you should form a trust. First is wealth preservation and asset protection, so that your assets are protected from risks which you are facing inside your life. risk from creditors, risk from separating spouses, risk from children who don't know how to manage money, and other such risks, right? That wealth protection is the major objective of trust, and I'll do some case studies with you to illustrate this also. Then estate planning and probate avoidance to ensure that my property post my death goes to the people I want it to go at the time I want it to go, in the manner and mode I want it to go, and in the amount and proportion I want it to. If you want to control your property post your death from your grave, trust is the only way to ensure it. Wills will not be able to do it because will is a one time play. Many of you would say, if I ask you, how would you give your properties? You will say, first it goes to my wife, then to my children. And you will write that in your will. Problem is, once a will is implemented, it stops. It's a one time play. That means after it goes to your wife, it is now wife's will, her property, not your will. Your will has stopped just by transferring it. And now she will decide where it goes. So if you want to ensure after me it goes to my wife and whatever remains goes to my children, trust is the only way to ensure will not work. So if you want to ensure that your inheritance takes place over multiple people in sequence, trust is the only way to ensure will would not be able to do it. Second is probate avoidance. What is probate? The certification of a will by a competent court is called probate. After your death, the court has to certify the validity of the will and give the executor the power to implement the will. That process is called probate. And probate is very costly, time consuming, irritant for the family. To avoid probate, you can create a trust. Why is probate required? Because there is a transfer post death. In your will, the property was in your name. Through the will, it is transferred to the next person whom you have mentioned as beneficiary in your will. But suppose I have transferred a property to the trust during my lifetime. Is any further transfer required after my death? No. It is a trust property, it will remain trust property. Only the beneficiary name would change in the trust. When there is no transfer, there is no need of a trust. So if post-death transfer is required, then probate is required. If the transfer is already done during your lifetime, probate is not required. Very simple. If I ask you a very simple question, which I ask generally people, who is the best executor of your will? आपकी will का best executor कौन है? Implementer कौन? The best person to implement your will is you yourself. And in a trust, you have implemented your will in your lifetime only. Now there can be no challenge to it, no, no need of any ambiguity. Everything is done during your lifetime. So that's one of the reasons why people create a trust. Control and flexibility. Control, I have already told you. Control the property during your lifetime and post your death also. Flexibility means you can put conditions. You can put conditions in a trust which you cannot do in a will. Some of you might say, if my son marries a Hindu, he gets my wealth, otherwise he doesn't. That cannot be enforced in a will. If my spouse remarries, she loses my wealth. That cannot be enforced in a will. If my children are major, they will get control of the asset. If they are minor, somebody else would manage it, and this would be the person. But Ravi will not be able to do it. Trust will be able to do it. So flexibility and control is more prominent in a trust than a will. Preservation of privacy and confidentiality, right? Trust is a secret document, confidential document. Will becomes public because it has to be probated. And what does will contain? Details of your assets and details of your relationships, which you might not like the world to know. So these are all reasons why why trust is a better medium of inheritance planning than a will. Right? I'll now take you through some use case scenarios, and you will, which you might see in your circle, or some of you might be encountering these, but the purpose is only to make you relate to what we are saying, and some of you would be able to relate, right? So let's take the first case, which is about a couple, which is Ritesh and Sonal. They are urban HNI couple with minor children. And what are their details? They have 9 crore in financial assets, 7 crore in real estate. They have minor children, aged parents, and cross nomination, no will or trust. Properties, the real estate is solely in the husband's name. Now, the problem is, if the husband dies, who are his legal heirs? The legal heirs of a Hindu male are his mother, his wife, and children. So he has two children, one mother and one wife. So if he dies without a will, it would be divided equally amongst four people. Is it acceptable to Ritesh? Or would he like that first it goes to my wife, then to my children? If he wants that first it goes to my wife, then to my children, then even a will not help, because if will only ensure it goes to the wife. But if he wants to ensure first it goes to wife, then to children, he has to make a trust. Okay. I'll also talk about one more risk which I foresee, and it's my job to uh, tell you the risk, right? Tell you the risk. What is the chances that post your death your spouse remarries and has a set of children who are not your children? If you avoid that situation, create a trust, not a will. Because in a trust, you can say till that person is only my spouse, they will get this asset. If they become somebody else's spouse, it goes to my children directly, bypassing them. Right? All of this is possible. Right? There are other problems also. Sorry. The other problem is minor require court appointed guardians for assets. Because his children are minor, court would appoint guardians for the children. If you want to avoid that situation, and guardian would have control over the assets of the children and get the custody of the children. If you want to avoid that situation, create a letter of guardianship plus a private family trust. Right? High value real estate gets split, illiquid conflict. His real estate is owned in four equal parts. Much of it is undivisible. He is a flat in suppose Mumbai. One fourth belongs to his mother, one fourth to mother, one fourth to his elder son, one to the younger daughter. How can I divide a illiquid real estate? But they are owners, right? Last risk which I have talked about is future marital risk. His children will marry one day and they will have spouses who might become interested in the real estate and wealth of their in-laws. And if they separate from the children, they might take away part of that wealth as alimony claims. All these things I can avoid in a trust. All these things I can avoid in a trust, right? And this is how I'll do it if I were you. We create mutual joint wills and a revocable living trust. How is this revocable living trust created? Ritesh and his wife become the original settlers. They are the original trustees, both of them, and all four of them are beneficiaries. With with Ritesh initially having the discretionary power to decide who gets what. Post Ritesh's death, his wife decides who gets what. After both of them, there are two scenarios. Children are still minor, children are major. If children are still minor, they appoint a person whom they trust as a trustee of the trust. And and This trustee will only be able to work or use the trust funds as per the terms and conditions mentioned in the trust. That means you can say, for each child, I am giving 5 gram gold equivalent money every month for their living expenses and educational expenses. When the child wants to go to a higher education, this much amount is given. When the child is married, this much amount is given. When the child wants to start a new business, once in a lifetime, I'm giving this money. So what are you doing? Post your death, you are controlling use of assets for your children, of your children, but from your children also. You are doing all of that together. That's the beauty of the trust. At a certain age, the children become the trustees, and at a certain stage, these amount are split between the daughter and the son, if you want, or this continues till the lifetime of your children, and it is given, and a major portion of them is given at some stage of life, remaining continues for your grandchildren. All of that is possible in a trust. All of that is possible in a trust. So that is basically a structure which I have talked about, right? So you now understand how it works, right? This is also a scenario which I usually face. Couple with substantial wealth and distant children, right? This is a couple. These are an aged couple, right? One is 74 years, second is 70, live in Lucknow, and these are real life cases which I am talking about. Huh? Names are changed, other things are same. They have two children. One child is Rakesh, settled in Dubai, and Nisha married, living in Bangalore. These are their assets, right? Now, what are their key concerns? First concern is health risks. If they mentally or physically become incapacitated and they have assets in their individual names, who would be able to operate them? And under what conditions can you put terms and conditions? You might say, we have joint accounts, right? We hold it jointly. But can you put conditions in a joint account usage? No, the survivor can use it in any proportion. I can control it through a trust. I can say, of all my assets inside the trust, this is what my spouse is allowed to withdraw for me and herself, right? Because they might be misled by people. They might act irrationally. They might not have the wisdom to take financial decisions, right? That's the problem. Asset mismanagement, difficulty managing investments, tenants, and paperwork alone. Many of you would have a spouse who is not financially savvy, legally savvy, cannot do the paperwork. That's one of the big risks, and especially for elder people. Lack of immediate family support. Children are far away, unable to help day to day. And this fourth point is very important: emotional or legal exploitation. Risk of influence from domestic staff, distant relatives, fraudsters, right? All of these are risks. Future inheritance disputes. After they pass away, both of them, children might disagree or or fight among themselves or face difficulty getting hold of the property because they are distant properties in some other city or state. They might not be able to do all that legwork required for it. And last is emergency medical decision making. No clarity on who will take financial healthcare decision if they become incapacitated. All these risks I can manage through a private family trust, and that's the beauty of it, right? So what they do, they establish a revocable living trust. They transfer all major assets into a private family trust. They serve as initial trustees and beneficiary, retaining control during their lifetime. They appoint successor trustees after them, right? After one of us passes away, both our children are added as trustees. We add our chartered accountant as a trustee. We add our financial advisor as a trustee. All of that is possible so that they are experts managing this money for them or for their children, along with the children, right? I can give the surviving spouse out of the two veto powers to overrule any decision made by any other trustee. So there's a complete control remains with the couple till any one of them survives. All of that is very much doable inside a trust, right? Uh, what does it do? It enables smooth transition of control. if they become mentally or physically incapacitated or pass away. Because the transfer is already occurred and I have told who is the next controller after me. There is succession of controller after them or beneficiary after them. They define distribution mechanism, right? Uh, I can create after their death two schedules. Schedules mean two baskets, buckets, one for their son, one for their daughter, inside the trust itself, just for accounting purposes, and allow each child, as per my terms and condition, to withdraw money from this bucket of theirs, and also stop children from taking out money as per the terms and condition. I do everything, and I decided today, right? Distribution can be staggered, purpose linked, education, healthcare, milestone related, work related, success related. I can reward them for something extraordinary they achieve. I can motivate them, right? We build a medical and financial power only within the trust vehicle. Embed emergency authority to manage medical decision financial via trustees. Add protective clauses like no contest clause. If any child challenges this trust, he will get nothing. I can put a clause like that in the trustee. Anti-alienation clause, right? Which basically does not allow any creditors, in-law, or third party to claim any asset inside the trust for a obligation of the child. Spendthrift clause. Spendthrift means how do I protect this money against wasteful beneficiaries? Sudden wealth post the death of the parent is very difficult to manage by many children. So I put clauses to regulate what can be withdrawn and for what purpose, right? This is how it will work for a elderly couple, and you can control it for maybe till your grandchildren or your great grandchildren ages. I can continue it for like that. This is okay. I've just concluded all of this in what I've told, right? You can just read it. This is what I've done already with you. So for parents, it's very, very important that this elderly couple has overcome all their problems, living problem and after death problems, through a trust, through a trust.
Uh, sir, can you also elaborate? You remember we had discussed a case in which we had a elderly couple who were in India and their children were in US and they had multiple properties in India.
I
And
have
we had
made that a
discussed.
case also.
Ah,
I'll come to it.
okay, sir. Thank you, sir.
Okay,
Thank you.
okay, okay, okay. Now, this is a scenario three where a business owner with unequal hair involvement. So many of you would be business owners, and one of your child is working with you, and other children are not working. And biggest problem with parent is what do I do after me? How do I share this business with this child and the other child also? Right? This is a big problem for parents to decide. Right? So this is a Rajiv Malhotra. He's a exporter. He has three children: Arav, Meera, and Rohan. Right? Arav is actively involved in the business. Meera and Rohan are not, and these are their assets. Right? And see, the major asset is the business. Right? Most businessmen create their biggest asset as their business, and business is in the hands of Rajiv and Arav. If something happens to Rajiv, what happens to the business? That's the biggest concern of the parent, right? Because business otherwise is one third each, which would be very detrimental to the business, right? Second concern is Rajiv has extended personal guarantees of business loans, right? If the business loan gets bad, apart from his collateralized business assets, his personal assets are also at risk because he has given personal guarantees. Arav will want to run the business. Meera and Rohan may demand equal share in value, not control. Bungalow and other personal assets will become point of dispute if Mira and Rohan demand cash out, right? I think all of you are able to relate to this. What are the key risks identified? Business risk to personal assets. I have already told. Bank can seize mutual fund rental property in case of default because of the loan. If Rajiv passes away or incapacitated, no legal structure defines how Araf continues the operation without interference from his brother and sister. Mira and Rohan may demand equal asset value, forcing business to be sold, broken up, or heavily borrowed against. If heirs want their share in cash, Arab may be forced to liquidate business and personal assets. In absence of a trust, courts process delays asset to risk disruption and business continuity. Right? Court can intervene and there will be a delay. How a trust solves the problem? Rajiv transfers shares of the business to a business succession trust. Arav gets the management right, not direct ownership. Business continuity is protected after Rajiv's demise. Personal assets are moved to a trust where each of the beneficiary has equal share in the personal trust, right? But but I add some clauses in the personal and the business trust, which are buy and sell clause. If Mira Rohn want to exit, they have to first offer it to Arav and then they can exit. So there is right of first refusal clause. If any of the family member wants to sell their share in business or any personal asset, they have first to offer it to the remaining people in the family. And I can even define the formula to arrive at that value of that asset and other clauses that prevent somebody to misuse this clause to demand something extra from the family than what he's getting outside, right? That's called right of first refusal. Then I can put a tag along clause that if you want to sell your share and I say tag along me, then you have to sell my share also. You can't sell only your share and make the property a problem for all of us, right? So those kind of things I can add in a trust, not any other place. Insurance earmark corpus trust to meet cash need. So one thing which Rajiv could have done if he would have got a very good financial advisor or wealth manager like Akshat could be that when he's Akshat solves this problem for this person, he's asked Rajiv create a keyman insurance which is equal to the share of each child in the business, right? And and give this insurance or assign this insurance to this trust. And when Rajiv passes away, this trust will have this money. And there would be a buy-sell agreement which allows Araf to take this money from the insurance company, pay it to the brother and sister, and buy their shares. And that would be the most smart thing a person can do. Because I have ensured that my children get the money and the person who is running the business gets the business without me paying anything. I have only paid the premium. Right? A term plan would cost nothing. It would cost nothing. Right? Such a beautiful way of ensuring that the non-involved heirs are taken care of. Right? Now comes what Akshat was talking. Parents with NRI children. Right? So this is a parent couple, Rajesh and Kavita, parents with NRI children based in Vadodara. Problem is cross-border inheritance uh, complexity. Family, Rajesh Patel 67, Kavita Patel 63, they reside there. They own these kind of assets. They have two children, Rahul and Neha, both US citizen, settled in California with no intention to return to India. How will Rahul, concerns, how will Rahul and Neha inherit Indian property without legal hassle or delay? No will or nomination leads to probate delays and title disputes. Even if there is a will, who will get the will probated? Who will come to India to get it done? You know, who will enforce this will? US estate tax applied to the children on inheritance from India, right? Inheritance over 13.61 million is taxable up to 40% in US. And in UK, the threshold is even lesser. They will want their children be able to manage Indian real estate from abroad. Will the children be able to do it? The real estate is in India, their children are abroad. Will they be able to manage it? No power attorneys are limited, and selling or renting from US is difficult. Both of them are difficult. Can they? Can the children send inherited money back to US freely? There are FEMA limits on repatriation, which is 1 million USD per person per year without RBI approval. Will their wealth be lost to taxes, delay, or mismanagement without planning? The answer is likely yes. And the solution is trust. Trust. They create an Indian private family trust. The couple settle their assets into a trust based in India. They are initial trustees and beneficiaries, and the children who are outside are named as successor beneficiaries in the trust and successor trustees also. But one thing to remember is this trust at all time should have at least one Indian trustee. So after both of them, they might have to appoint their financial advisor, chartered accountant, lawyer, or a friend or a family member in India as one of the trustees along with the children. So that point of effective management is always India, right? US estate tax mitigation, because the children don't own the asset after the death of the parent, is still in the name of the trust. There is no estate tax, right? Trust corpus bypass direct estate valuation upon death. Plan of sale of unused property and convert proceeds into financial assets can be done by empowering trustees with predefined rights to sell or lease in future. The, the trustee in India has the power to sign on the instructions of these two children to sell the property or to rent the property. Right? Legal and digital documentation, they need to maintain asset register, what they own, power of attorney, letter of wishes, and digital asset instructions. They have to align it with FATCA and FBAR reporting to ensure compliance for US based children. And that's easily done. But what I'm telling you is the trust is the only way to ensure that your non-resident children are taken care of and get your property without dispute and easily manageable way after both of you, right? It's the only way to ensure. This is a scenario 5, and this also I come very often. I'll just summarize this. These are a couple, right? They have only one child who's a daughter who is married for 8 years, no children yet. Son-in-law is from a well-off family, but financial control lies with it. The son-in-law is not in control of his finances. His parents or other brothers and sisters are still controlling his finances. This is in a joint family kind of setup, right? Concerns of the parent is, will Priya have full independent control of the wealth they leave for her after both of them? Concern is inheritance may be influenced or controlled by in-laws or spouse of Priya. If Priya's marriage turns hostile or ends in divorce, can her husband claim inherited assets? Big if. Will Priya be emotionally or socially pressurized to share her inheritance? Suppose the in-laws or the husband runs into a financial trouble and they ask her, you have some assets from your parents' side, please give it to us. Once we are over this thing, then we'll return it to you. Can she say no? Legally, she can say no, but morally and emotionally, can she say no? No, right? Because if she says no, the relationship is spoiled. Will the asset remain protected against across Priya's life even after their own device? Not unless a structured plan with legal safeguards in place. And what do they want to ensure? Suresh and Lata want to ensure that daughter receives full benefit of their legacy without external influence and retains legal, emotional, and financial control over it, no matter what happens in the future. And if I can ensure this for this couple, they would be most happy to do it. And the way I do it is private family trust, which we call as daughter protection trust. They create a private family trust, settle their assets into a revocable or irrevocable private trust. Daughter Priya is named as sole primary beneficiary after the passing away of the parents. Right? The trust structure prevents Priya from becoming the direct legal owner of the assets. Since she doesn't own the corpus, the assets are not part of marital or joint property and are shielded by claims of spouses or in-laws. Right? income can be distributed to Priya monthly income, monthly, annually, or for specific purposes like health. She has a health problem, give this much money. She wants to study further, give this much. When she becomes old and is not able to fend for herself, retirement, etc. Corpus is preserved unless certain conditions like financial emergency or child needs are arise. No joint access with spouse or in-laws. I'll put a clause, right? Her husband and her in-laws cannot become trustees in this trust. I'll put a specific clause in the trust so that only people who can become trustees in this trust after Priya are her children and people she trusts apart from these people. So Priya retains independent financial security, right? So I have tried to give you as many use cases as possible. Last step is anti-alienation. Priya cannot transfer pledge her interest in the trust. She cannot mortgage it. She can't transfer it. Prevent creditors and estate partner from attaching the trust because there are clauses and prevent challenges from extended families or because I have put a no contest clause in the trust, right? Upon Priya's passing, corpus can be passed to her children or to a children trust created by her for her children as per her will if the flexibility is retained. So how beautiful I have managed it for Priya, her parents and her future children. That's the power of the trust and no other structure can do it for you, right? So I have covered all of these, right? Why you should create a trust, right? So I'll just take it further from.
Question. One of our sir, audience has asked, what are the cons of making a trust, sir? We have spoken about the benefits, but what are the drawbacks of having a trust?
The only con I can say is after your death, you can't change the terms and conditions in the trust, right? It is flexible, changeable till you are alive, your wife is alive. After both of you, the terms and conditions are set in stone, right? And that's the purpose of creating the trust, right? I can allow you to change it during your lifetime. I can create a revocable trust, a changeable trust. But if I allow them to change after your death, then there's no need of creating a trust, no use. So it becomes an inflexible instrument post the death of the couple. That's the major con of a trust, right? And second con is if you want to transfer real estate to the trust, existing real estate of yours to the trust, stamp duty has to be paid over it. To avoid that, we create wills in favor of the trust. For real estate, financial assets we transfer during the lifetime of a person. Right? These are two major things which I face while creating the trust. Right? Others, there is no major challenge inside a trust.
Great, sir. Sir, another question that has come. Thank you for your answer, sir. Another question that has come is, without the will, and when there's an event of an untimely death of a life insurance policy holder,
Mm.
who can be the claimants of the money if nomination is given only to the wife? And
So,
the follow-up question is, how can trust safeguard such kind of issues?
so please appreciate that in September 2017, Insurance Amendment Act was passed by the Parliament. And one of the features of that act was it amended Section 39 of the Insurance Act, which deals with nomination. And they introduced a special nominee only in case of life insurance, which is called the beneficial nominee. And they said if in a life insurance policy where claim arises after September 2017, the nominee is either of the parent, spouse, or child of the life assured, such a nominee would be called as beneficial nominee. And beneficial nominee would become the owner of the funds to the exclusion of other legal heirs. So in this case, if their wife is the nominee and this claim is arising post September 2017, wife becomes the owner of the entire assets and other legal heirs cannot claim it. But is it good or bad? Depends. But but there is a purpose. You took this life insurance because you wanted to protect your spouse and minor children. Now problem is it goes to one person and it is at the whims and mercy of that one person who gets it after you. Can you do something about it? Yes. You can assign this policy to a private family trust. where you say when this claim money comes after my death, it will be used in such manner by such people. Now I am controlling use of a insurance proceed claim post my death, which you cannot do with any other structure, which you cannot do with any other structure. So trust can really help you.
Got it. Thank you, sir. Rohit, sir, I hope the answer is clear. If you want to ask your questions, please do feel to ask. Sir, Nimish sir also has a question. So it's a follow-up to the original thing that you had said that so after a trust has been created, the
Mhm.
terms and conditions of the trust can be amended until the settlers of the trusts are alive. But after the settlers are have expired, then the terms and conditions of the trust cannot be amended.
No, I can create a trust where they can be amended. But problem is, what's the use of creating such a trust? You
Hmm.
created the trust because after you, whatever terms and conditions you said are held, and you have to protect it from them for them. If you allow them to change it, then that purpose is lost. If you ask me legally, can I do it? Yes. But practically, do I do it? No. Because that's the entire purpose of creating the trust.
Right, right. Uh, Nimish sir, any I hope this is clear. अगर आप if any other question you can please ask sir.
Can I continue a little more?
Sure, sir, sure, sure, sure. Please do. Yeah.
Yeah, okay, okay. Uh, this I have covered. Wills I have covered. Okay. So I'll not do these. I'll go to the taxation of the trust. Right. So Akshay had told that I would be discussing taxation of a trust. So I'll do it. Right. There are three incidents of taxation in the trust. Right. First is when the asset is transferred to the trust. What is the tax implication? Second is when the income arises on this asset inside the trust. What is the tax implication? Third is when this asset or income is passed through to the beneficiary, what is the tax incidence? There are three possible tax incidents. Now, all three of them depend on the type of trust created, right? And that's the complexity in a trust. I cannot say a private family trust, this would happen. No, it depends on what type of trust have you created that decides the taxability and the incidence of tax. So let me just take you through what are the determinants of trust tax. One is type of trust. Second is status of the beneficiaries. Third is type of income generated by the trust. If you tell me these three, I'll tell you what is the taxation, right? Because it changes with all three of them, right? Okay. So there are two major type of trust, private and public trust. There are various ways of defining the trust. I know at least 50 kinds of trust, right? So one is a private trust, second is a public trust. Private trust, it is created for number of individual which are within your family or which can be ascertained very easily. Public trust is for general public. Private trust is limited in duration. Public trust is perpetual in duration. Private trust, you can distribute both corpus and income, but generally in a public trust, only income is distributed, not the corpus. Private trust is not regulated by a government entity. Generally, public trusts are regulated by somebody called the charity commissioner. Private trusts are cause or person specific. Public trusts are only cause specific or therefore general public. So what we are discussing today is the private trust, which are created for private individuals, not for public at large. Now, on the basis of changeability of trust, it could be a revocable trust or an irrevocable trust. So I can create a private revocable trust or a private irrevocable trust. What's the difference? In a revocable trust, the settler reserves the right to change or dissolve the trust. Irrevocable trust, once the property is transferred, settler loses all rights over the property and the trustee. He cannot change it, he cannot revoke it. Revocable trust, as you know, it gives more control to the settler. Irrevocable trust take away control from the settler. The feature is in a revocable trust, the Income Tax Act doesn't consider revocable transfer of a capital asset as transfer. So the asset continues to be taxed in the name of the settler. So I have given 1 crore rupees worth of mutual fund to a trust, right? And it's a revocable trust. Income Tax Act says this, although it's civil in a civil law, it's in the name of the trust. Income tax says because it's a revocable trust, you have not actually transferred it. So they will continue taxing it in my hand, not in the hands of the trust. Huh, trust can pay the tax on the behalf of the settler, and that can be done. But the obligation or the tax structure is defined by the settler, person who gave, not on the trust structure or the beneficiaries. Irrevocable trust, once the asset is transferred, it becomes the trust property. And either it is taxed in the hands of the trust or the beneficiary. If it is a discretionary trust, in the hands of the trust. If it is a specific trust, in the hands of the beneficiary. So suppose I have given this 1 crore of mutual fund to, to a trust which is an irrevocable trust. And there three of my children are equal beneficiaries in this trust, and I have defined their shares. So Income Tax Act would make this capital gain be 1/3 for each of the child. But if it is a discretionary trust, they would say, we don't know whose it is, so we'll tax it to the highest marginal rate, which is still 12.5% for a capital gain. But suppose it was rent, income, or dividend, then highest marginal rate would be 30%, right? So it depends on revocable or irrevocable. Problem with revocable trust is it does not give protection against creditors and predators. If you transfer assets to a revocable trust, you are not safeguarding yourself against creditors or predators, because court would say you have actually not transferred it. You have retained control. If you want protection against creditors, predators, separating spouses, create an irrevocable trust, not a revocable trust. Right? The second way of doing the trust is living or testamentary trust. If the trust is created during my lifetime, it is a living trust. If it comes into existence after my death, it becomes a testamentary trust, right? If it is a real estate and it is transferred through a will, stamp duty is saved. But if I create a living trust and then transfer properties to the trust during my lifetime, stamp duty is paid. But problem is will is challengeable. So if I don't want to leave inheritance disputes or challengeability to my inheritance, a living trust transferring properties during my lifetime is the way to go. I say 6-7% of the stamp duty is the insurance premium you are paying to ensure that what you want happens without risk to your family members, right? Then comes discretionary and specific trust. Discretionary trust, the share of the beneficiary is not fixed. It is decided by the trustees. Specific trust, it is fixed by the settler. Specific trust income is taxed at the slab of the beneficiary. Discretionary trust income is taxed at the highest marginal rate. Now, what is the highest marginal rate of taxation? 30% plus surcharge? Yes. Currently, also, what tax are you paying? Most of you are at the 30% bracket. So it doesn't matter, it's discretionary or specific. 30 का 30 ही रहेगा, बदलेगा नहीं. पर डिस्क्रिशनरी में एक फायदा है. फायदा क्या है कि सपोज आई हैव 3 चिल्ड्रन, वन ऑफ द चाइल्ड इज फेसिंग अ क्रेडिटर और स्पाउस इशू, एंड आई हैव द डिस्क्रिशन टू डिसाइड हु गेट्स व्हाट. I will not give it to the child who is facing the issue till that issue is solved. And after the issue is solved, I'll start giving him again. So discretionary gives more protection. So if you ask me what is the best trust structure for asset protection? It is living irrevocable discretionary trust. I create a living trust which is irrevocable and discretionary. If I do it, I get 100% asset protection. Right? I am. This can go on. I have a whole class for it, but I think uh, we'll end it here only. Right? If you have any questions, I can answer those questions for you.
Sure, sir. Hi, I'm Purav, and thank you for this session, sir. It's quite a lot to process, to be honest. So, apologies if I might ask a redundant question. But,
No
sir,
issue.
I had a question here. Let's say someone makes a trust and passes away, and the trustees also, maybe they have nominated one or two or maybe three trustees, and for some reason, for none of the trustees also survive the purpose of the trust, then what happens to the trust? Who?
Trust would always have a provision of appointing successor trustees. Either the outgoing trustees appoint a successor trustee, or in case they fail to do it, beneficiaries would have the power to appoint the trustees, or even if they fail, the court has the ultimate authority to appoint the trustees. Trust would
Oh,
never be wanting for trustees. That we ensure in the trust draft.
okay, sir. Just a small follow-up question. If a court, if it ever comes to a situation of a court appointing a trustee, do they appoint an independent individual
It's
or
up to the trust. It's up to the court.
okay.
You can't control that once it goes to the court. But yes, in the trust deed, you can say the court can only appoint people from our family. That
Okay,
provision you can put inside the trust deed.
got it. Thank you.
Yeah,
Clarify.
yeah. So
Uh, so there are a
we'll
few
come to the
questions as well.
yeah, yeah.
Um, when should a will be made and when should a trust be made? How does one take a decision?
So if you just want to give it and then stop, you know, after me it goes to this person, and I don't feel my will be challenged, then maybe a will is okay. But if you want to control it beyond giving, trust is required. If you foresee there are chances of somebody challenging your will, trust is required, right? So use cases I've given. But if it is a very simple case, a couple, one child, no chance of of anybody challenging the will, they are fully trust their child to take care of the assets, right? The child is not wasteful, so maybe a will is more than enough.
Right. And I'm attending your course, sir, the becoming a certified trust and an estate planner, CTP. There was one
Yeah,
term that you had used. If one wants to control your property and assets from the grave, the best
yeah,
way is to form a trust.
yeah, yeah,
I still remember
yeah,
that.
yeah.
Yeah. Okay, sir. Thank you. We'll go on to the next question.
One question can I ask very quickly,
Sure,
sir?
sure, sure. Please do, Pranav. Yeah.
Sir, can a trustee be also be a beneficiary, or is that
Yeah.
not?
Generally, trustees are made beneficiaries. The
Okay,
beneficiaries are made trustees of it.
okay, okay. Thank
Then, sir, the question is, if the corpus, one second. Sir, the question is that in a will, when the children get the inheritance, then they don't have to pay any capital gains tax. When they get the income as inheritance, but when they get it via a trust, because they'll be beneficiaries, is capital gains applicable?
No, see, please understand. In a trust, there is no transfer of the title. The asset remains in the name of the trust, even if children become beneficiaries. So if there is no asset, the transfer of title, there is no sale purchase, no? There is no transfer. There is no question of capital gain. Yeah, you can ask me what happens if this asset moves out of the trust to the children. Still no capital gain is paid. But when the child sells this property from their name, then capital gain is paid and the cost of acquisition of the original buyer. That would happen both in case of a will and as well as in trust. So trusts are tax neutral in that regard.
Right. So I think, sir, Jitendra sir had asked this question. So, sir, just to clarify, even in an inheritance, capital gains tax is payable when the beneficiary sells the assets.
Right? Yeah. Same is here. Same
Same
is
is
here.
with the trust. Yeah.
Yeah.
Thank you, sir. So there was a mention of special kind of insurance to be taken for a living discretionary trust and the debt balancing mechanism. Can you please
Key-
speak on
It's a
that
key
more?
man policy. It's a key man policy taken by the companies where there's a term plan which is equal to the debt obligation or the share of a non-involved child whom you want to buy the share for. And there is a that policy is keyman policy, maybe a term plan. Keyman policy is a type of, it's not a type of
Yeah,
policy, it's a way of buying a policy, right? And
yeah.
plans could be term plan, paid up plan, whole life plan, it could be anything. This policy is assigned to the trust so that money comes to the trust and the beneficiaries have a buy sell agreement inside the trust. If this money comes after the passing away of my father, we will give our shares, and the brother who is running the company would get the shares and we'll get the money. That's done during the parents' lifetime only.
Right, sir. Then a question has come that under an irrevocable trust, once
Mhm.
the mutual funds and properties has been moved to the trust, can it still be sold?
Any number of times,
Yeah.
any number of times, trustees sell it as per the trust deed, and you can make it obligatory for them to buy it back. Right? You say if you sell up, if you sell my real estate within 1 year, you have to buy a similar property. You can put that clause, or you say you keep it as you wish to keep. The trustees decided. It's up to you.
Hmm.
You want to control, control you. And if you say that this property cannot be sold, I can also do that. So I have known people who say I have 8 properties. Two of them are very dear to me. I will like this to remain in my family for several generations. So they don't allow selling those 2 properties. Other 6 you can sell and do whatever you want. So these kind of things I can do.
So basically, ma'am, the you it's all depends how the trust deed is drafted, and based on that, you have the full flexibility to to do whatever you want. Then the question has come is, what is the process of creating a trust?
So first of all, you should know what you want. And that's the most difficult thing to decide. What you want. And I can guarantee you most of you don't know what you want. Unless you meet a professional and he starts asking you questions and conditions over the questions. If this happens, then what happens? If this happens, what happens? Right? A simple question like, would you consider the adopted children of your children as lineal descendants, or only blood relatives, lineal blood descendant would be considered as lineal descendant? These small questions matter too much to me as a trust drafter. And these are things which you might not have even thought about, right? So those what you want is the most important thing. Once you tell me what you want under various conditions, based on that I can draft a trust deed, right? Once that trust deed is drafted, we register it in the sub registrar office with the initial capital of 10,000 or 11,000 rupees. वो Indians में 11,000 भी चलता होगा, शुभ होता है, राइट? तो 10,000 की जगह 11,000 कराते हैं ज्यादातर. तो 11,000 रुपीज की इनिशियल कैपिटल दिखाई और इसको हमने रजिस्टर करा दी सब रजिस्टर ऑफिस. Once it is registered, we apply for the PAN card of the trust. Once the registered deed and PAN card is there, I can open bank accounts, demat accounts, etc. And the trust is up and running. You can start transferring properties, assets into the trust. That's how. And the only regulatory obligation in a trust is you have to file the income tax return every year. There's no other regulatory compliance of the trust. So it's much less than any partnership or a private limited company which you ever run.
Right, sir. Then the question is that at the time of creation of trust, when the property is moved from the person's name to the trust name, is capital gains required to pay at that
No,
point in time?
no. I tell you there are two types of trust, revocable and irrevocable. In a revocable trust, the Income Tax Act doesn't consider it to be a transfer. So there is no chance of capital gain. But even in irrevocable trust, there is a section 47(3) which says any capital asset transferred to a irrevocable trust, there will be no incidence of capital gain. So both the cases, there is no capital gain when you transfer it from individual to the trust.
Okay, this is also new to me, sir. I was not. I thought that irrevocable trust capital gains is required to be
No,
paid.
there,
But thank you
there's
for the
exclusion.
clarification.
Uh,
Okay,
it is for private family trust. HUF also 47(3) holds, and one more entity, association of
okay,
person. It holds 47(3) is all three. There is no capital gains.
nice. Okay, sir. Then can we do commercial activity under a trust like agri related?
Anything, any
Anything, yeah.
work can be done in the trust, but generally business and activities are not done in the trust where you hold personal assets. And there are two reasons for it. First reason is business is risky. And the reason I've created a trust is to separate risk from non-risk. So you are putting the matchbox and the inflammable material together. That's wrong. Second reason is if a trust does business, entire income of the trust is taxed at the highest marginal rate of taxation. So if you want to do business, not agriculture, agriculture is anyhow tax-free income, right? But if it is a business to be done by trust, I will create separate trust for business and separate for person. Business trust would be taxed at the highest rate, no issues.
Got it, sir. What are the one-time and recurring costs of managing a trust?
So one-time cost is basically two costs. One is drafting the trust deed, which is around 2.5 lakh rupees. Registration is another 25,000 rupees. And recurring cost is only filing the income tax return, which will be at 10-15,000 a year. That's it. No other cost.
Great. Any other questions that anyone has?
You can unmute also and ask if you want.
Yes, yes. Yes, so one question has come up. How does a private trust differ from HUF in terms of tax scope and liabilities?
See, in an HUF, the Karta is unlimited liability,
Hmm,
right? Even his personal assets are at risk. In a trust, trustee's liability is only when he does something which is against the trust, right? So in that way, trusts are more secure. When it comes to taxability, trusts don't enjoy the slab rates as the HUF enjoys. But Akshat, I can do something very beautiful. I can make HUF as the beneficiary of a trust, and income should be given to this HUF. So let me give you a scenario. I have a parent with three sons, right? They can form four HUFs.
hmm,
One parent, three sons, four HUFs.
correct,
I
correct, sir.
create a trust where these four HUFs are the beneficiary. And in the trust, it is written the karta of each HUF would act as a trustee. I transfer 1 crore rupees into this trust, right? From the father. In normal circumstances, it would be clubbed and income would be
Correct,
added to the right.
father.
But here,
Yeah.
because it is transferred to a trust, not the HUF, there is no clubbing. But income beneficiaries of this trust would be those four HUFs. Suppose it is getting 8 lakh rupees a year, 2 lakh for each HUF, no tax has to be paid.
Oh, wow.
So there are many
Oh,
wow
that's a
things you can
great
do with
idea,
a
sir.
trust. There are many
Yes, I.
wow things you can do. You can do with the trust. When you
But this will be
marry two
applicable.
entities,
But this will
when
be
you marry two
applicable.
entities, now, Akshat, when you marry
Yeah.
two entities, you create wonders of the world.
So this will be applicable in a revocable trust
Irrevocable trust.
as under
Irrevocable
section
trust में specific
47(3).
होगा ना. हाँ, irrevocable
Wow.
trust बनाऊंगा ना. And this 1 crore is never diluted. The beauty is this. वो एक नहीं तो क्या होगा, वो लड़कों की वाइफ आएंगी, वो भी उस 1 करोड़ के शेयर होल्डर बन जाएंगी. इसमें नहीं बन सकती, क्योंकि 1 करोड़
क्योंकि वो
तो दिया ही
ट्रस्ट
नहीं
का
उनको.
पार्ट है.
वो तो ट्रस्ट का ही रहेगा हमेशा, अगली अगली 4 जनरेशन तक. खाली
बट
क्या जाएगा, इनकम जाएगी 2-2 लाख रुपए, वो खर्च कर दो बच्चों पे. वहां से फीस दे दो उनकी, एटीसी ले लो 1.5 लाख रुपए का. कितना कुछ कर सकते हो.
but sir, finally the trust assets will go to the HUF and at that time HUF
एच
वो HUF का प्रॉपर्टी
एच यू एफ
बनेगा.
नेवर डाइज. एच यू एफ नेवर
हाँ.
डाइज. ट्रस्ट विल
बट वो
नेवर डाई. इट्स अ परपेचुअल ट्रस्ट, चलती रहेगी. 4 जनरेशन का तो मेरा मेरा जिम्मेवारी है. 4 के बाद उनको पावर दे देंगे रिन्यू करने की.
I fantastic idea. I didn't think of this either.
So I thought about it myself. It's not done by anybody else, and I have done it for many clients of mine.
Great, sir. Great. Sir, just one more thing I wanted to mention. If you could speak about the one thing that you're speaking at, you're spoken at Gift City about private God and the public God. That was a very, very interesting point.
So many of us have emotional assets, right? Which are more dear to us than financial any financial. I'll give you an example. Many of us have houses in our villages, right? This house in the village has no financial value for us, it's only emotional value. And what do we want? We want that this house always remains in the family, whatever happens, but it's emotional. Now, problem by creating a normal trust is trust should have an end date. Private trust cannot be perpetual in India. Now, to overcome this, what do? I place the an ideal. हम सबके यहाँ ना कुल देवी या कुल देवता होते हैं, जो हमारे कुल देवी या कुल देवता होते हैं, राइट? जैसे मेरी फैमिली में काली माँ इज अ कुल देवी. So what we do, we place the ideal of Kali Ma inside our house, which is in the village, and make this god, the Devi, the owner of the trust, the beneficiary of the trust. See, that's what I said. There are two kinds of gods, public god and private god. The god in the mandir temple is a public god, but god inside your house is your private god. And it's an artificial judicial person. And I can make them as beneficiary. Now, once this house is transferred to the trust, it belongs to whom? The God.
देखो
And God never dies.
देखो आ रहा है छोटू ब्लैक.
God never
Sorry,
dies. Right? God
It's
never dies.
drizzling again. It's
sorry,
drizzling
sorry,
again.
sorry, sir. Sorry. Hi, Ankit. Okay. Sorry, sir, for this. Yeah.
Yeah. So God never dies. So this house would continue forever in my house, and I can transfer other village properties also to the trust and give money to the trustees who are my children as reward for taking care of the God,
Hmm.
as salary or something like that. Right? Best use case of God. You never use God like that, right? And it's a beautiful way of ensuring perpetual trust without fight. And when I did it for my village house, now it is shared by 4 generations, and there would be at least 14, 15 families who are claimants of their house. Till we did this, there was constant fighting. Moment I transferred it in the name of the Kuldevi, nobody wants to fight. Now they are fighting against the Kuldevi. वो लड़ाई झगड़ा खत्म हो जाता है, फिर वो हाथ जोड़ के कहते हैं कि अब बताओ क्या करना है. अब सबका समान हो गया वो, right? It creates that bonding because nobody wants to be at the wrong side of the god, right? So those are kinds of things you can do in a private family trust. Beautiful ways of doing.
Great, sir.
Uh,
Great, sir. Thank you so much, sir, for this. This concept itself blew me. When I heard you at Gift City, it was amazing. So thank you, everyone. It was, thank you, sir, for this amazing session.
Thank you,
It
sir.
was really, really enlightening, and every time I hear from you, we learn something new. So thank you again for this. If any one of our audience has any questions, please do send them to us. We will get them answered, with Deepak sir, and we will revert back to you. So again, sir, thank you so much for taking time on
Thank
of
you.
your
Thank you.
busy schedule and giving us your Sunday morning. And appreciate everyone,
Pleasure was mine.
for taking the time. Thank you, sir.
Thanks. Thank you. Thank you very much.
Yes, sir. And yes, we will be putting this session on YouTube, and we will be sharing the link with all of you. We have the link of the session that we did in January, which was on wills, letter of guardianship, springable durable power of attorney. We shall be sharing the link of that as well, for sure. Thank you so
Thank
much,
you.
sir.
Thanks a
And
lot. Thank you. Thank you. Thank you. Thank you.
thank you, sir. Thank you. Bye bye.